Can a government violate your charter rights, freeze bank accounts, criminalize protest, lose in court twice, and still have the media ask whether this is somehow the opposition's problem? Because that's exactly what just happened in Canada. Last week, the Federal Court of Appeal delivered one of the most damning rulings against a sitting government in modern Canadian history. It confirmed that the Trudeau government's use of the Emergencies Act during the Freedom Convoy was unlawful, unconstitutional, and a violation of charter rights, not partially, not procedurally, completely. Three judges, nearly 200 pages of arguments, and the conclusion was unanimous. Every government appeal was dismissed. Yet instead of wall-to-wall coverage about historic government overreach, Canadians were treated to a familiar distraction, spin, minimization, and a sudden pivot to asking whether this creates political problems for Pierre Poilievre. That alone tells you how uncomfortable this ruling really is. Welcome to the Northern Bridge, Global Stories, Afro-Canadian Lens. I'm your host, and today we're cutting through the noise to explain what the court actually ruled, why the Emergencies Act never met the legal threshold, and why this decision matters far beyond the Freedom Convoy. The court's message could not have been clearer. The government invoked the Emergencies Act without meeting the legal requirements set out in law. It wasn't a close call. It wasn't a matter of interpretation. The appeals court explicitly upheld every part of the lower court's decision, rejecting the government's arguments across the board. The ruling confirmed that declaring a public order emergency was unreasonable, that emergency regulations violated freedom of expression, that freezing bank accounts violated protections against unreasonable search and seizure, and that peaceful protesters had their charter rights infringed. And it's important to understand something here. This wasn't a partisan ruling. The original decision came from a judge appointed by the Trudeau government itself. The appeals court reviewed his reasoning line by line and found it sound. Politics didn't save anyone here. The law spoke for itself. At the heart of this case is a simple principle the government hoped Canadians would never test. The Emergencies Act is supposed to be a last resort. It cannot be used because it's convenient. It cannot be used because it might work faster. And it certainly cannot be used when existing laws are already doing the job. The court reaffirmed that point clearly. Provinces across the country handle protests using normal legal tools. The RCMP dealt with weapon seizures at Coutts using the criminal code. Ontario managed enforcement outside Ottawa without invoking emergency powers. The evidence showed province after province that the situation could be and was handled without suspending civil liberties. Yet the federal government claimed this was a national emergency that could not be addressed under any other law. The court rejected that claim outright. That matters because the entire justification for invoking the Emergencies Act collapses without it. And with it collapses the narrative Canadians were told for years, that this was an insurrection, that democracy itself was under threat, that extraordinary powers were the only option. The appeals court addressed that narrative head-on. It ruled that the emergency regulations criminalized the entire protest and infringed the rights of peaceful demonstrators who were simply expressing dissatisfaction with government policy. That sentence alone rewrites the historical record. If this had truly been an insurrection, if protesters were attempting to overthrow the government, the court would have upheld the emergency powers. It didn't because the evidence never supported that claim. And then there's the part of this ruling that should chill every Canadian, regardless of political affiliation, the bank account seizures. During the hearings, the RCMP superintendent overseeing enforcement admitted under cross-examination that accounts were frozen based on bare belief. No objective standard, no judicial authorization, no due process, just belief. The court ruled that this breached charter protections against unreasonable search and seizure. Think about what that means. In modern Canada, the government froze citizens' financial lives based on belief alone. People lost access to money, lost jobs, faced investigations without charges, without convictions, and without an objective evidentiary standard. That isn't law enforcement, that's arbitrary power. And it's exactly why this ruling goes far beyond the convoy itself. The Emergencies Act can only be invoked if there is a genuine threat to national security, and Canadian law already defines what that means. Espionage, sabotage, foreign interference, serious violence, violent overthrow of government. What the law explicitly excludes is lawful protest, advocacy, and dissent, even when it's disruptive, unpopular, or inconvenient. Economic disruption is not a national security threat, political embarrassment is not a national security threat, and peaceful protest is explicitly protected. The court confirmed what the law already says: the emergency threshold was never met. So, how did major media outlets respond to one of the most significant charter rulings in Canadian history? By shrugging. On a national panel, a Liberal commentator dismissed the decision by saying Canadians had largely forgotten about this, forgotten about frozen bank accounts, forgotten about mass arrests, forgotten about suspended rights. Imagine that sentence being uttered if a conservative government had done this. And then, almost on cue, the discussion pivoted away from government accountability to whether this ruling somehow creates problems for Pierre Poilievre. That rhetorical sleight of hand tells you everything. One conservative voice cut through the nonsense with a simple question. If the government was ruled wrong twice and citizens were harmed, how is that a problem for the opposition? It isn't. But reframing accountability as partisan strategy has become the default move when institutions fail. Now, the Carney government faces a dilemma of its own making. It can appeal to the Supreme Court and almost certainly lose again. It can do nothing and face a wave of civil lawsuits. Or it can accept the ruling and create a restitution process for those whose rights were violated. Every option costs taxpayers money. None impose personal consequences on the decision makers who invoked emergency powers unlawfully, and that may be the most troubling lesson of all. In Canada, a government can suspend rights, violate the Charter, lose in court years later, and no one goes to jail. No one is personally accountable. The damage is done, the precedent is set, and the bill is passed to the public. That's why this ruling matters so much. It's not about whether you supported the convoy. It's not about whether you agreed with the message. It's about whether constitutional rights are real or conditional on political convenience. The courts have now answered that question clearly. Rights were violated. The government was wrong. Peaceful protest was criminalized. The only remaining question is whether Canadians are willing to confront that reality, or whether we'll allow it to be buried under spin, distraction, and selective amnesia. At the Northern Bridge, we believe Canadians deserve better than that. We believe understanding what actually happened is the first step toward ensuring it never happens again. Because if emergency powers can be used once against people the political class dislikes, they can be used again. And next time, it might be against you. Thanks for watching. Until next time, this is the Northern Bridge, Global Stories, Afro-Canadian Lens.